A recent Supreme Court decision might have just handed towns a powerful new tool to fight back against state mandates. So today, we're going to break down a really compelling legal argument that connects a landmark ruling to a controversial law in Connecticut. The real question is, could this actually be a game changer for local control?
Okay, let me ask you this. What if the state passed a law that forced your town to accept massive new development projects, with you having no say and with no financial help to deal with the fallout? Well, according to the source material we're looking at, this isn't just some what-if scenario. It's the reality for towns in Connecticut under a law known as HB8002.
So to really get a grip on this argument, we have to rewind to a crucial Supreme Court case from 2024, Sheetz versus the County of El Dorado. And trust me, this case is the foundation for everything we're about to talk about.
Okay, so what was this case really about? Well, it boiled down to a pretty simple but absolutely fundamental question. On one side, you had the County of El Dorado. Their argument was basically, hey, if a legislature imposes development fees through a law, they're immune from the Constitution's takings clause. That's the rule that says the government can't just take your property without paying for it. But George Sheetz said, whoa, not so fast. A taking is a taking. It doesn't matter if it comes from a county board or from a new law.
All right, so the big question, how did the Supreme Court land on this? Well, let me tell you, it wasn't even a debate. It was a unanimous 9-0 decision. I mean, unanimous. The court sided completely with Sheetz, and that sent a massive signal that the government's power has very clear constitutional limits.
So, this huge ruling really hammered home three critical principles. First and foremost, legislatures, they are not exempt from the takings clause. They can't just legislate their way around the Constitution. Second, any mandatory development burdens they impose, they have to be able to stand up to constitutional scrutiny. And third, and this is a big one, just saying you have broad policy reasons isn't a free pass to impose these burdens without compensation.
Okay, so we've got the legal precedent down. Now, let's connect the dots. This is where the source material draws a straight line from that Sheetz ruling, right over to this controversial state law in Connecticut, HB 8002.
So you're probably asking, what is HB 8002? Well, the source material breaks it down like this. It's a state law that essentially forces towns to absorb all these new density requirements, new development burdens, and zoning overrides, and here's the kicker, all without getting a dime to help manage it.
And this right here, this is the heart of the argument. You can literally see how the source material maps the principles from Sheetz directly onto the reality of HB 8002. The Supreme Court said you can't force land use burdens without compensation. Well, the argument is that's exactly what HB 82 does. The court demanded that these things meet constitutional scrutiny. The claim is HB 82 just bypasses local zoning and due process altogether. And the court said policy goals aren't an excuse. The source points out that HB 82 uses the banner of housing policy to override local authority.
And that's why the source material uses this really powerful metaphor. It calls the Sheetz ruling a constitutional shield for towns. But what does that actually mean in practice? What kind of new firepower does this supposedly give these towns?
Well, the argument is that this ruling basically unlocks a whole new toolbox for municipalities. It's said to bolster everything from their local zoning authority and their home rule powers to opening up new legal avenues like using environmental protection laws for challenges or filing for what's called a declaratory judgment, and even making direct claims for uncompensated takings. And all of this builds up to a really bold, really powerful conclusion from the source material. When you combine Connecticut's constitutional protections with the Sheetz ruling, HB 8002 does not survive. The core idea is that the combined legal weight of state and federal law is just too much for this law to handle.
Okay, so let's say the legal argument holds water. What's next? Well, the source material doesn't just stop at identifying the problem. It lays out a whole proposed path forward for towns and residents who want to take action.
It's actually a pretty clear step-by-step strategy. It starts at the local level, towns passing resolutions and enacting ordinances to officially push back. Then it moves to the public with proclamations and even individual constitutional affidavits to build a strong record of opposition. And the final piece of the puzzle, taking the fight to the courts. And at the end of the day, the source is really clear on one thing. This isn't framed as a partisan issue. It's about something bigger. As they put it, this is not about party politics. This is about the Constitution, local sovereignty, and protecting the rights of Connecticut's people.
So there you have it. The argument is that the Sheetz ruling could be a massive game changer for towns in Connecticut. But this really makes you wonder, right? What does this mean for the rest of the country? How is this dynamic, this clash between federal court rulings and state legislation, going to shape land use fights everywhere? That's a huge question, and it's one that's definitely going to define the future of local control for years to come.